This is Barry Zalma speaking for Zalma on Insurance on YouTube. I am a California lawyer, now retired from the practice of law. I spend my time now acting as an insurance claims consultant and expert witness, and author of insurance claims and insurance coverage books. I also do this daily YouTube communication concerning insurance coverage matters. Today we're going to talk about the adjusting of a first-party property loss and what the adjuster must do at the beginning of the claim proceeding. After the notice of loss, the adjuster must meet with and begin his investigation. And the beginning of a first-party property claims investigation is the scope of loss. If there is a loss to structures or contents, the scope of loss is generated at the first meeting between the adjuster and the insured. The scope of loss is where both parties agree on the categories of property damaged, and at this point, they're not trying to ascertain the amount of loss. However, their findings will be used later to arrive at a total claim amount. These agreements are not to the amount of loss, but to the general categories of loss that will be used by the adjuster along with the assistance of experts retained by the adjuster and the individual insured. In a typical fire loss, these categories include the number of rooms damaged by fire, the length, width, and height of each room, the number of openings, doors, and windows in the damaged room, since you don't put walls up over doors and windows. You must remove those and their square footage from the calculation for replacement of a damaged wall. The type of wall coverings, whether it's paint, drywall, plaster, lath and plaster, siding, or any other type of wallpaper or wall covering. The need to remove and replace drywall, lath and plaster, structural lumber, hardware, etc. The need to remove and replace fixtures and appliances. The contents of the dwelling, the type, quality, and quantity of contents and or structural amenities, the type, quality, content, and amount and description of the damaged property that is salvageable, the type, quality, and quantity of the non-repairable portions of the property, any other damages observed to any part of the structure or its contents. A dispute between the parties concerning coverage and scope of loss might well be resolved by the court on a summary judgment, particularly to the extent it involves matters of contract interpretation, which are questions of law for the court. But the exact amount of the statement of loss and the scope of loss are two different items. The scope of loss sets forth the amount and extent of damages. To convert the scope of loss to dollars, which is what an insurance company pays when there is a loss, the adjuster and the insured's representatives use the detailed information contained in a scope of loss to write a repair estimate based on his or her experience and tools made available by the insurer. Many insurers and independent adjusters use software programs like Xactimate, Bex, Marshall & Swift, or their own in-house software to produce the estimates. In a fire case, the software would be used to create a repair estimate and to assist in evaluating estimates presented by the independent fire reconstruction contractors retained by the insurer or the insured or both. Most independent contractors these days also use computer-generated systems like Xactimate and will, if directed properly by the adjuster, follow the same scope of loss the adjuster and the insured agreed upon at the first meeting. Many contractors make the work of the adjuster easier by so doing. The adjuster should require each builder estimating a loss to use his or her agreed scope of loss so that multiple bids could be easily compared and so that he or she may consider changing the scope if the bidding contractors discover additional damage not observed at the time the scope of loss was prepared. Adjusters must always be flexible and never commit to a scope of loss and Xactimate estimate as the be-all and end-all of claims. The software takes the dimensions of each room and applies unit cost to the dimensions to create an estimate. A unit cost as applied to fire reconstruction is a dollar amount that years of study and experience have shown is necessary to repair a particular part of a structure. The unit costs were developed by time studies of restoration company staff at work that determined the amount of time needed to perform a particular repair. The cost of the labor and the materials used are evaluated with a mathematical formula so that a particular unit cost can be reached that includes the contractor's overhead and profit. Similar unit costs exist for every category of property where construction or reconstruction is required. And these unit costs, each adjuster must understand, vary by location. A unit cost that will work perfectly well in a Los Angeles suburb may not work at all and may undervalue the need in a mountain resort area like Vail or Sun Valley. If a licensed contractor is not being asked to assess the damage, an experienced property adjuster can still obtain a reasonable idea of the cost of repair, sufficient to allow him or her to negotiate a settlement with the insured. He or she will measure each affected room, applying the Pythagorean theorem to measure triangular shapes and accounting for missing walls of three-walled rooms. The adjuster's estimate can be used to negotiate a final price with the bidding reconstruction contractors or an insured who wishes to use his own labor or that of friends or colleagues. Failing to create a complete and thorough scope of loss can be very expensive to an insurer. In a case where the insurer from the beginning showed the insurer was more interested in avoiding paying the claim than trying to make a fair statement, a public adjuster complained he could not get the insurer's vice president or its adjuster to discuss what might be covered. The adjuster canceled an appointment to determine the scope of loss and never made another. The insurer never sent anyone to the building to determine the scope of loss. The insurer rebuffed the public adjuster's attempts even to discuss the matter. It made no payment until shortly before trial. The court in that case concluded that the insurer's actions were clearly not those of an insurer acting in good faith. This is a case called Track Mortgage Group versus Crusader Insurance, a California Court of Appeal decision. So it is wise and appropriate first to create a good scope of loss, and then it is up to the insurer working with the insured to obtain competitive estimates for the repair of the structure. If the loss is large enough to warrant multiple estimates, either during assessment of the scope of loss or immediately after it, the adjuster should obtain the competitive estimates from 2 or more licensed contractors. The contractors preparing competitive estimates must be instructed to write their estimates based on the scope of loss agreed between the insured and the insurer. The adjuster should walk through the site of the loss with the contractors so that if there is any question as to the scope of loss, it can be resolved with the adjuster, the insured, and the bidding contractors at the scene of the loss. Once the estimates are prepared, on the same scope, the adjuster can compare the estimates, lumber for lumber, window for window, and drywall for drywall, and learn which contractor found more damages than those found at the creation of the original scope of loss. The comparison would then allow the insurer and the insured to determine an exact amount of loss, an exact extent of loss, and then comparing the bids, be able to arrive at a reasonable cost for the repair and replacement of the structure. The purpose of the bid comparison is to establish that all of the contractors have presented a comprehensive estimate of all the work required to effect a complete repair and avoid supplemental estimates. If the low bidder has left out a category of work, it is often found on the bid comparison, and that when the category is added, the low bidder is found to be, in fact, the high bidder. The adjuster should therefore never accept a bid on its face without completing a thorough comparison of the bids presented by all contractors bidding on the work. If all of the contractors have submitted bids, are licensed, and are equally able to perform the reconstruction work with the same quality of workmanship that existed before the loss, it is best to recommend to the insured the use of a builder who has successfully estimated a similar scope of work in the past and has completed the work successfully and satisfied the property owner. Every final adjustment should be based primarily on the most competitive bid that includes the full scope of loss prepared by a competent reconstruction contractor. Every insurance claims person must understand that the schedule of prices and costs included in a software program like Xactimate were estimates for the purpose of a bid comparison. The contractor who is the successful bidder is to be compensated based on actual quantities of work, materials used as measured by the adjuster, and the unit cost must be revised if the location of the work is different than that upon which the unit cost in the Xactimate program were created. The changes in unit cost, depending on location, can cause serious disputes between the insurer, the insured, and the various contractors. If you're interested in more detail concerning the preparation of a proper scope of loss and the adjustment of claims, see my book, Zelma on Insurance Claims, Part 107, as well as my book, The Compact Book of Adjusting Property Claims, all available as both Kindle books and paperbacks from Amazon.com and described in detail on my website by clicking on the link to the Insurance Claims Library. Thank you for your attention.